The broadcast is now starting. All attendees are in listen-only mode.
All right. Good morning and good afternoon, everyone, and welcome to this Ask the Expert session. We'll talk today about the EU Clinical Trials Regulation, the CTR, and the Clinical Trial Information System, the CTIS. As you all probably know, the EU CTR entered into force end of January this year, and the first approved trials are now showing up in CTIS. We've got some early experience that we'd like to share with you today on how to manage successfully your transition and your upcoming submissions. My name is Adeline, and I'm an Associate Director at VCLS. I will be your host for today's session. For those who are familiar with this format, it's not a formal webinar, which is listen-only mode. Today, we'd like to provide you with the opportunity to interact directly with our VCLS experts. So this is why we have activated the mic for all attendees. So if you'd like to ask a question, you can just unmute yourself and show the question. You can turn your camera if you want. And you have also the possibility to send your questions through the chat function on GoToWebinar panel. But as a start, let's start with a quick introduction of our experts today, Ruxandra and Lucie. They both have years of experience in clinical regulations. Ruxandra is a certified EMA CTIS sponsor master trainer. She is qualified to disseminate the knowledge on the submission of clinical trials in Europe under the CTR. And she ensures clients' readiness for EU CTR implementation and provides regulatory oversight of the clinical trial process, in particular with the submission strategy for international studies. Lucie has more than 10 years of experience in setting up and managing clinical safety and pharmacovigilance systems. This includes the preparations of safety management plan, the management of individual case safety reports, and ADRA vigilance registration. So after this first short introduction, we can start. So feel free to send your questions. Feel free to jump in anytime during the presentation. We also received a couple of questions just before the webinar, and we can start with this first question. So let's start. The first question would be, when should you transition your ongoing trial to the EU CTR? And I guess the question is for you, Alexandra, the first one.
Yes, indeed. Hello, everyone, and thank you, Adeline, for the introduction. So basically, if your clinical trial that you started under the Clinical Trials Directive is expected to still be ongoing on the 31st of January 2025, this means that you will have to transition your trial to the Clinical Trials Regulation. And you should do so before the 31st of January 2025. There is another instance in which you will have to transition your trial to the Clinical Trials Regulation, even if this trial is expected to end sooner than this date. And this case is if you would like to conduct your trial in an additional EU member state. Because initial clinical trial applications under the directive will not be possible anymore from the 31st of January 2023. So this means that you will need to transition your clinical trial to the regulation first, and then submit a request to add the new member state in CTIS. Also, if you do not have any such obligations or constraints, let's say, you can also transition your trial to the regulation if you would like to benefit from a coordinated assessment on your substantial modifications or on your annual safety reports. In any case, this decision to transition your trial would need to be carefully considered so that you would make sure to choose the best strategy for your trial, taking into account the constraints and also the benefits.
Thank you, Alexandra. So feel free to raise your questions during the presentation. You just need to unmute, and then you can ask the question. So we've just received a second one. Can one switch from the trial-centric approach to the organization-centric approach? Who would like to take it? Yeah, Alexandra.
Maybe I can take
Yes,
this
sure.
one. Thank you. So this actually relates to the user management functionalities in CTIS. Basically, the choice of the user management approach is not something explicit, but this depends actually on having an appointed sponsor high-level administrator or not for your sponsor organization. Because if you don't have a sponsor high-level administrator, any CTIS user can connect to the portal now and create a clinical trial application on your behalf. This means that from that moment onwards, the trial-centric approach is going to be chosen for you. So the user management is done at trial level. From this point, you as a sponsor would not be able to regroup all of your trials and the users managing these trials under your umbrella. This is why you will basically not be able to switch from the trial-centric approach to the organization-centric approach. So if you do wish to have oversight on your trials and users, we suggest to consider the organization-centric approach, especially if you expect to have a higher number of clinical trials conducted in the EU and if you are a commercial sponsor.
Thank you, Alexandra. That was very, very clear. Okay. Okay, I can see the fourth question that we just received is more regarding safety. How and to whom to submit your safety reports under the EU CTR? And I guess this one is for you, Lucy.
Yes, thank you, Adeline. Good afternoon, everybody. So reporting under the EU CTR. So one of the aims of the EU CTR as far as safety reporting is concerned is to really streamline and simplify the safety reporting via a single submission for each type of report and a harmonized assessment. So in practice, this means that for SUSAR submissions, sponsors will be expected to submit their SUSARs via user vigilance to EVCTM only, and there'll be no additional submissions. And also for annual safety reports, there'll be a single submission via the CTIS. So there will, again, no additional submissions to competent authorities or ethics committees. Now, during the transition phase, as previously mentioned by Alexandra, up until 2025, 31st of January 2025, there could be clinical trials still approved under the directive or under the regulation. And during this phase, basically safety reports should be submitted according to the legal framework under which they're approved, the trial is approved. So if your trial is approved under the directive, the reporting rules of the directive apply. So for example, you would need to submit your SUSARs and DSURs to ethics committees. And for trials approved under the regulation, the single submission rule will apply. So if you have several trials ongoing, some approved under the directive and some under the regulation, you would apply the reporting rules applicable to each trial concerned. However, in doing so, sponsors should try to avoid duplicate reporting. So for example, if an annual safety report is submitted via CTIS because there is a trial ongoing under the EU CTR, the sponsor would not need to submit that same ASR again to a competent authority who has another trial approved under the directive with the same product, the same sponsor. I hope that's clear.
Thank you, Lucy. And I think we get the follow-up question. which is who can submit the ISR?
Okay, so in CTIS, yes, so there are specific roles for the annual safety report submission in CTIS. There is a specific ASR submitter role, and any user or any person who wants to submit an ASR will need to have this role in the CTIS. And then perhaps, Roxandra, you could maybe elaborate a little bit on the roles in CTIS and how these are allocated.
Yes, sure. Thank you, Lucy. So basically, we know that the clinical trial administrator user role is a super user, and it is expected to be able to do many things in CTIS. But this CT admin does not have the necessary permissions to be able to submit an annual safety report. So the CT admin would need to assign the ASR submitter role to themselves in order to be able to submit annual safety reports. So this would be the additional implications of this specific role.
Thank you. Okay, the questions are coming up. Feel free to really post your question and by using the GoToWebinar panel questions. So, okay, there is another question about registration, I think. How can we check if our organization is already registered? Alexandra, you can answer this question?
Yes, for this question, I think that I would need a bit more details about the actual registration, because there are two possibilities here. Maybe the person who asked this question refers to the sponsor high-level administrator. For this sponsor high-level administrator to be registered in IAM, an active request needs to be submitted with an assignment letter. So you would need to know if any of your users has actually submitted such a request supported by a relevant appointment letter. And the second option, maybe you are referring to your registration as a sponsor in the organization management system, namely the OMS. For this, you would need to go to the OMS website and search in the organizations to see if your organization is registered. If not, you would need to submit a request to register it.
Thank you. Okay. We then have a question regarding the investigator brochure. And the question is, do we need to adjust our investigator brochure now, because they will be posted and public?
This is a question that could have several options as response. The investigator's brochure is one of the core documents of the study. And there are several strategies in terms of managing it. For example, if sponsors are concerned about the commercial confidential information that would be included in this document, and this document has been already prepared, sponsors have the option to redact the commercially confidential information along with the protected personal data, of course, before submitting it to the CTIS. Also, depending on the trial category, there are some options to actually request a deferral for this kind of document. So The protected personal data should be, in any case, redacted, because these should not be released in the public domain. But in terms of commercially confidential information, if the sponsor considers that at the end of the deferral period, these commercially confidential information would not be commercially confidential anymore, then the deferral request would be sufficient to satisfy this need for confidentiality. There is also a third case in which the investigator's brochure is not prepared yet, and there are no specific time constraints in submitting it as soon as possible. In this case, the sponsor could look at their procedures for preparing such a document and make sure that the amount of commercially confidential information and protected personal data is reduced to a minimum, so that eventually there will be no need to redact. I hope this addresses your question. If not, please feel free to follow up on it.
Thank you. Okay, we get some new questions in our panel. So the first one is, I think, a follow-up question on safety regarding DSUR submission. So the question is, if you are in the process of transitioning one of the studies to the CTR, but approval is pending, at the same time you have a DSUR that needs to be submitted, how should this be approached? Submit the DSUR via the directive, meaning in the old way, and any implication on your ongoing transition application?
Okay, yes, I can answer that one.
Thank you.
So, I mean, Roxandra, please correct me if I'm wrong, but as my understanding is that if the DSUR will only be able to be submitted in CTIS once the trial is approved. So in this case, if the trial is not yet approved, the DSUR submission would need to be done according to the rules of the directive. And this DSUR submission wouldn't have any implication on the application that's ongoing. It's reviewed separately to the clinical trial applications, so this shouldn't have any impact on that.
Yes, I can confirm that the possibility to notify an annual safety report is open for a specific trial only after the decision in CTIS. So this cannot actually be done before for clinical trials still under evaluation.
Thank you.
Thank you for the clarification. We also received a question regarding the timelines for evaluation. So what is the current experience with timelines of evaluation? Are those specified in the regulation fulfilled? I guess we can share the experience that we have now.
Yes, I can maybe take this question, Adeline.
Sure.
So in terms of current experience, if we go to the CTIS, we can actually see some clinical trial applications that have been approved. So we can see there that the timelines are actually shorter than those stipulated by the clinical trials regulation. The approval was quite quick in these several cases that we have already. Also, there is an important thing to mention regarding the timelines in the regulation. Namely, these are maximum timelines. So we cannot have delays for an initial clinical trial application for a product that is not an advanced therapy medicinal product. We cannot have more than approximately 106 days. I'm saying approximately because if a deadline falls on a weekend, it will actually be deferred to the next working day. So there might be additional 2 or 3 days on each application. I hope this addresses your question.
Okay. We have a question on the legal representative. So, as a Swiss-based company, which requirements should we expect from the legal representative for trials conducted in Europe? Access to our QMS system, submission in CTIS by our company account of full legal representative, who will have the responsibility for sponsor oversight. Would like to take the question?
Yes, maybe I can take this one. Thank you. So the clinical trial directive, as we have been used to already, includes only a very brief mention of the legal representative. Namely, for non-EU sponsors, this legal representative must be established in the EU. And the member states have had the possibility to complement this via implementation in their national legal framework, the way they wish to. But now the clinical trials regulation further specifies the responsibilities of this EU legal representative, namely ensuring compliance with the sponsor's obligations stipulated in the CTR. And also the EU legal representative should be the addressee for all the communications with the sponsor under the CTR. This latter provision can be interpreted a bit differently, so that the legal representative would have the obligation to respond to questions if questions related to a clinical trial are being received from a member state. The means through which the legal representative may choose to ensure compliance with these requirements of the regulation are, however, not specified in the regulation. So this means that these should be covered in a contract between the sponsor and the EU legal representative. The choice of these means would actually depend on each provider of EU legal representation services, but they, of course, may include a review of the sponsor's quality management system or, very importantly, a full visibility of the submissions that are performed in CTIS. It is worth mentioning here also that member states may agree to have just a contact point established in their territory and not necessarily a EU legal representative, but they must actively agree to this.
Thank you. It was not an easy one. So we have a few minutes left, so feel free to unmute your mic and jump in. We would be happy to answer your questions. We got another one regarding the co-sponsorship. How does this work? Can we split sponsorship between different participating countries? Do we need to determine one overall sponsor?
I can maybe take this one too. So as per our interpretation of the CTR, there are two types of sponsor responsibilities. Those that can be split with the co-sponsors and those that cannot be split or cannot be taken jointly by all the co-sponsors. So for the following responsibilities, there should be a joint agreement in a contract, so that only one sponsor takes one of these responsibilities. So the first responsibility would be the compliance with the sponsor's obligations in the authorization procedure. So interaction in CTIS only a single sponsor or just one of the co-sponsors should be responsible for this. There should be just one sponsor acting as the contact point for questions, and also one sponsor implementing the corrective measures imposed by the member states. For the other sponsor responsibilities, if this is not stipulated differently in the co-sponsorship contract, all of the co-sponsors are jointly responsible for these. In conclusion, to address this question more specifically, it is not necessary to determine one overall sponsor. And in terms of splitting responsibilities per country, these must be carefully considered, taking into account the restrictions that I just mentioned. So in CTIS, we cannot have one sponsor responsible for one country and another for another country, because there is a common assessment and it would be difficult to separate.
Thank you for the very detailed answer. Okay, a new one. When submitting a new trial, can we cross-refer to core documents, IB, IMPD, already submitted in other trials, and in a way link them? Similar question for subsequent amendment of such documents concerning several trials. Do they need to be submitted separately to all trials?
This is a question for which the response may be quite long, because in order to be able to connect trials between them, there are some restrictions. For example, to have exactly the same list of member states concerned and the same core documents, more or less. However, we can indeed cross-refer to core documents. For example, submit a single substantial amendment on the investigator's brochure for several trials. We would need to specify this in the cover letter. And also for the IMPD, there is actually a possibility here in case we have a third party providing the IMP and also the IMPD, and you would need to, and the main sponsor would not need to see and have access to this IMPD. In this case, the recommendation would be to just submit a letter cross-referring the IMPD if this IMPD has been already submitted for a different trial. Maybe more implications of this are actually described in the Q&A on the clinical trials regulation available in Neutralex Volume 10.
Thank you, Alexandra. Okay. I think we have 1 minute left. And yeah, let's address the last question. How does the coordinated safety assessment work in practice? I'm assuming this is more for you this time, Lucy.
Yeah, absolutely. Yeah, I can answer that. So the coordinated safety assessment between member states, so the idea, as I mentioned previously, is to have a single submission and a coordinated assessment to streamline the safety reporting and the assessment. So the sponsors will submit SUSARs and annual safety reports to the EMA, and the EMA will then forward the safety information to the member states concerned, and then they will cooperate in the assessment. Ethics committees can be involved in the assessment. It's a national, they'll be decided on a national level, depending on the country, whether the ethics committees will be involved in the assessment or not. And in order to coordinate the assessment, each active substance, ideally will be designated a safety assessing member state. And the safety assessing member state is then responsible for coordinating the safety assessment for that active substance. So in practice, this is done via screening and eudravigilance. So the safety assessing member states should screen eudravigilance on a regular basis. And if necessary, they can then request any additional information from sponsors. And also with the ASR, the annual safety report submission, so when the DSR is submitted, the safety assessing member state will compile the feedback from the different member states concerned. And then if there are any, we'll send requests for information to the sponsor and then review the response, coordinate the response once it has been received, and then issue a final assessment on the annual safety report. And if during their review of any of eudravigilance of CSARs or of the annual safety reports, if any safety concerns arise, the safety assessing member state would then make recommendations to the reporting member state of their trials and the concerned member states for the trials concerned, which will enable them to take any action as needed. For example, if a safety issue was identified, it may be they may request the reporting member states to put a trial on hold or to request further action from the sponsor.
Thank you, Lucy.
Sorry, thank you.
Okay, so this is the end of this Ask the Expert session. So we hope that we address all your questions. If not, we will reach out offline. And keep in mind that the questions and answers will be available on our website very soon. Thank you all. Thank you all for your active participation.
Thank you. Bye-bye.
Thank you. Bye-bye.